Hey there. We've got a lot to talk about today. In the Tati Westbrook defamation lawsuit against Without a Crystal Ball and KJ, there is a filing from the defendant's side. That's the Without a Crystal Ball KJ side. The filing is a motion to dismiss, and it's a fruit salad of stuff. So we're going to try to parse it. I'm going to tell you what's relevant, what is not relevant. My experience as an attorney that worked for judges that read motions like this and helped write opinions on motions like this. Ooh, we're gonna get into it. I've got my I Heart Cursey Words shirt on today. So be forewarned, there will be cursey words. And we're just gonna get right into it. If you're new here, I'm Emily D. Baker, the badass lawyer, host of the Get Legit Law and Shit podcast and legal commentator. I've been a licensed attorney for over 15 years, but I'm not your attorney, not legal advice. I am a big fan of the cursey words, so headphones are recommended. This is where the law nerds unite to break down the news stories that you want to hear about with facts, not fuckery. I would first like to point out, if you want your own Cursey Words shirt, there are lots of shirts. LawNerdShop.com is where they are. I'm going to pull up this legal document and break it down the way that I do for all of the legal documents that we talk about on this channel. I have breakdown videos on everything that's been filed in this case so far. And today it's time to talk about the defendant's motion to dismiss. This is the first time that KJ and Without a Crystal Ball have filed in court in this case. So we're going to take a look at what they had to say. I did a live video on this case where I broke down my first impressions, got into a lot of the statements in it, what was there. We're going to do a little bit more of the legal stuff today. And then, of course, before this goes to court on December 28th, there will be a response filed by Tati Westbrook's team of lawyers, including Michael Saltz, who this channel calls Saltsy, because sometimes he gets a little salty up on the Twitter. And, you know, it's hilarious. This is a standard procedural motion. A motion to dismiss can come at the beginning of the case. This also touches on jurisdiction. So it's also a motion saying this court is not the right place for this case for a variety of reasons. That has to come first. Like if you're going to talk about jurisdiction, it has to come up before you do anything else. I'm expecting that we will see a response to the motion to preserve evidence from the defendant, KJ and Without a Crystal Ball, shortly, because that motion's coming up on calendar first on December 18th. And then this will be heard after that. So there is still that pending motion, as we call it here, as the law nerds refer to it, the motion to not delete your shit. And that motion regards to social media behavior going on in this case by the defendant. Let's pull back up this motion. Defendant's motion to dismiss against the parties. Again, the parties in this case are Tati, her husband James, Halo Beauty Partners LLC, KJ, and Without a Crystal Ball. I'm going to try to not say Without a Crystal Ball a million times. It's a mouthful, y'all. This is 26 pages long. It's been brought to my attention by those who practice in federal court more than my ass does, that this judge has a standing order and that this goes against the page length. I'm sure it will come up in the response. The introduction gets into the fact that plaintiffs Tatiana and James Westbrook are prominent and notorious social media personalities in what is referred to as the beauty or beauty drama scene on YouTube. I consider them to be beauty gurus, whatever, call them whatever you want. I also don't think James is as much of a personality, but maybe. So the introduction characterizes who they are and really jumps right into the fact that Bye Sister happened, that Dramageddon happened, that Carmageddon happened, and lays out all the facts relating to that. What the introduction doesn't talk about is the shit that's in the defamation complaint that alleges that in 40 videos, there were statements made by KJ. It doesn't talk about any of that. It talks about Tati and James and Bye Sister and Jeffree Star and Shane Dawson and at some point PewDiePie and Trisha Paytas. But none of that goes to jurisdiction, which is here, and none of that goes to whether the complaint's sufficient, which is what a 12B6 motion to dismiss is. So it's not relevant unless they're arguing the defamation, but then they don't argue the defamation. So none of this is relevant. The harm here, from my perspective, and then we'll pull this back up and go through it. The harm here, from my perspective, is that I will show you how many pages this goes on and touch on some of the points. But a law clerk most likely is going to read this, which oftentimes is a licensed attorney who works for a judge to help parse everything. I did it as I was pending bar results and after I became a licensed attorney. And a lot of law students, and especially on the federal level, bright law students who have graduated and are waiting for bar results will clerk for judges and sometimes be permanent research attorneys to work with judges to help them go through the volume of work that they have. If you rile those people, they don't even want to get through your motion. If it were me, when I was a research attorney, I had a very particular judge and a not as particular judge. If this was beyond the page limit for my very particular judge, he would say, read it up to the page limit and nothing else. That would be how that would roll. Sometimes he would say, no, counsel, this is beyond my page limit. We're not even reading it. We're not even reading it. It's beyond our page limit. Rules matter. There are rules for a reason. Federal judges tend to run on the saltier level, not in a shady way. No shade meant by me, but in a very specific rule following way. So this could be the case where the judge is like, I don't even know what the fuck this is. I don't even know what the fuck this is. And I'm not like, we don't have the time to dive. We're in the middle of a pandemic. What the fuck's a Dramageddon? Why is it relevant to your causes? And when I went through this the first time, I went through it and went, okay. But then when we got to the point where they said, this is what we're alleging are the grounds for the motion to dismiss, I'm like, how is any of what's in this introduction relevant? And I still can't figure that out. Probably because it's not relevant. So let's get into it. I'm going to pull up, we're going to skip the introduction real quick and get back to it. I'm going to pull up where they state their legal causes for this motion. At the bottom of page 2, it goes into the complaint should be dismissed for several reasons. And the reason I'm having trouble with this is it's not in legal writing format with your issue being first, like the thing is this. The rule regarding the thing is this. Like this should be dismissed for failure to state a claim. The rule is 12B6 and the court has to find this and this and that. Then your argument, the reason the court should find this and this and that is because of these facts. And then the conclusion, which is therefore, based on the above, the court should dismiss this complaint for failure to state a claim. And that is the format that you typically see in a legal argument. The issue is this. The reason they did the shit that shouldn't have been done is this. The rule that the court needs to apply is this, and here's the standard. Let me lay it out for you, Judge. Then let me tell you why my facts meet that thing. Conclusion, you must do the thing that I've said that you should do. IRAC format. Issue, rule, analysis. Analysis, conclusion. Right. I say argument sometime. Analysis, same. In my mind, same. Don't come for me, lawyers. So they state the grounds they believe this motion to dismiss should be grounded, or that they're attacking in this motion to dismiss. That first, there's no personal jurisdiction, which means the court can't bring the Minnesota defendants into court. There's no jurisdiction over KJ and her business. That's first. Second, the plaintiffs named 100 Doe defendants, not uncommon, and that precludes the court's exercise of diversity jurisdiction, which I will get into when we get to that part. Okay, I'll get into it briefly. Diversity jurisdiction means all the parties are from different places. So in this case, Tati and James live in Washington. The business is in Nevada. KJ and the business and her business are in Minnesota. But if any of the Does are also in Washington, then it's not diverse. But in KJ's declaration, she says that she didn't work with anybody in Washington. So the argument's kind of out the door anyway, because in the complaint, they allege that the Does are people that are unknown because they were working with KJ. So the complaint tries to get to the fact that there's this underlying belief that somebody was working with her. And then in her signed under penalty of perjury affidavit, She says, no, I didn't work with anyone in the state of Washington. So that argument is kind of dead in the water, in my opinion. Third, plaintiffs have failed to include necessary and indispensable defendants, including Starr and Dawson. The whole motion, Jeffree Star's name is spelled with 2 R's. I'm trying not to be picky, but it bugs the shit out of me because his name is spelled with 1 R. Also, in the business partner lawsuit filed against Tati Westbrook and James by Clark Swanson, they spell Starr with 2 R's. Like, why are we spelling Starr with 2 R's? Can someone please tell me in the comments why we are spelling Jeffree Star's name with 2 R's? I don't understand why we're misspelling things. And it's weird to me that it's the same misspelling in the 2 different things. In the complaint from Swanson, the business partner, it spells Starr with 2 R's. But then if there's any reference to Starr filed by Tati's side, it's 1 R. I think it's 1 R. Tell me in the comments. I need y'all's input. I'm trying not to be picky, but it bugged the shit out of me. Fourth, the failure to state a claim for Consumer Privacy Act violations and intentional and negligent infliction of distress are not supported by the factual allegations. That is the only real 12b6 motion I saw in all of this. Like, you didn't plead it right. And then finally, the plaintiff's claim for civil harassment fails because there's no subject matter jurisdiction over it. They fail to submit the required sworn affidavit, and that the statute does not turn on defendant's conduct. I am interested to see what the response will be on the civil harassment claim. I'm interested to see that. The introduction facts should all go to one of those 4 things. It should all go to one of the 4 things we just talked about. But it goes into public self-made scandals and self-inflicted wounds, which would go to the defamation, but that's not argued here. It goes to her trying to take out her most prominent business rival. It says she tried to take out her most prominent business rival, 19-year-old James Charles. It gets into the Breaking My Silence video. It does say that Tati, in Breaking My Silence, alleged that Starr and Dawson engaged in this coercion as part of their far-flung and murderous conspiracy. So Jeffree Starr and Shane Dawson have a far-flung murderous conspiracy that was discussed in Breaking My Silence. I need to know your thoughts on what that is. So also in the comments, or just at me on Twitter. I'm the Emily D. Baker everywhere, because I need to know what the murderous part of the conspiracy was that I clearly missed in the Breaking My Silence video, because this former district attorney would be like, where's the murder plot? Where's the true crime? Is there true crime in the beauty drama tea? I don't think that there is. I'm just confused. Then it goes more into Dramageddon 2 and Carmageddon. It reserves that Dramageddon 1 was earlier, but doesn't define it. I was a little sad. I was like, can we talk about Dramageddon 1? Are we getting all of it in here? They talk about a PewDiePie video and the fact that he didn't like Bye Sister. More about Bye Sister. And then we get to the fact that the lawsuit, the filing of which, the business partner lawsuit, the filing of which was first reported by defendants Catherine Paulson and her corporation Without a Crystal Ball. 2 things. One, this comes up a lot, that she was the first that reported it. We know. If you guys haven't watched the drama videos about that particular quirk of all this, go watch them. But at this point, they call her Catherine Paulson. But she's sued as Katie Joy Paulson. And I don't understand why the shift throughout this document. It's very confusing to me. I didn't even touch on it yesterday in the live because it was, I was like, am I being picky? And I'm like, no, it's confusing. What's the defendant's name and why isn't it used consistently? But just days after the defendants broke the story of the Swanson lawsuit, plaintiffs filed this lawsuit against them. There's no mention of the 4 cease and desist over 18 months. But it gets into this conspiracy about the fact that Swanson is suing the Westbrooks for $5 million. That's not what's in the prayer for relief in this case. And then it gets into the fact that the underlying defamation case here is a $5 million case. Y'all know how I feel about it. This is not a $5 million case. It says exceeding $5 million, and the prayer for relief says an amount to be determined at trial. So it's not a lawsuit for $5 million. $5 million is the range where it says the damages can exceed $5 million, which gets into a jurisdictional requirement to get you into the court that has jurisdiction over big money cases. It's not that give us $5 million. It's an amount to be proven at trial. It bothers the shit out of me that everyone keeps saying that they're $5 million lawsuits. Show me where in any of the prayers for relief it says we're suing you for $5 million. Because none of the prayers for relief in any of the lawsuits say that. They also get into the fact that this lawsuit, they argue, is part public relations stunts, part intimidation. There were things that KJ had been saying on social media and in videos that some are still up, some have since been deleted, some go up and down. She talked about the intimidation. She talked about the meritless claims. And there were a few other statements that she used that made me think they were going to file an anti-SLAPP type of a response saying, hey, you're only suing us to stop us from speaking. I was, based on the language she was using, I'm like, are they going to do that? Are they going to file an anti-SLAPP? I was excited about it. I was like, file the anti-SLAPP. I would love to talk about it in this context, because anti-SLAPP is when somebody's legally speaking and legally exercising their rights. And this is a defamation suit, but also the anti-SLAPP statute in Washington was, ruled unconstitutional. I'm sure that her attorneys know that, but the language she was using was very aligned with a lot of the anti-SLAPP statutes, especially on this meritless intimidation, stopping me from speaking, trying to get me to not say anything. And I was like, I'll talk about that all day long. Anyway, the anti-SLAPP statute in Washington has been ruled unconstitutional. So there is no anti-SLAPP statute in Washington, but I was curious. I was curious to see if that would happen. And it gets into chilling further negative reporting about the Westbrooks. Going down, they talk about the Does. Plaintiff named 100 Doe defendants alleging they are unaware of their identity. A, that's not unusual. That's why you allege Does. And B, in the complaint, it says Does working with. So they're alleging the Does they don't know who we're working with, and they're expecting, Tati's side is expecting to see who was potentially working with KJ throughout the course of these defamatory statements in this case, and that's why they alleged the Does. But that argument, again, she said she didn't work with anyone in Washington in her sworn statement, so that argument kind of flies right out the window. I've never seen an attorney use the word silliness in a filing, but okay. This says, putting aside the patent silliness of plaintiff's attempt to blame a small YouTube channel located in Hanover, Minnesota for their injuries, the complaint should be dismissed now for several reasons. And then it gets into them. I've never. It feels like something that she would say more than something her lawyers would say, because I've seen a lot of videos of this is a big YouTube channel coming after a small YouTube channel. I just can't imagine an attorney being like, yes, the fact that you are a small YouTube channel has legal weight and relevance in any way. What? We've gone through the 5 things. Personal jurisdiction, the Doe defendants we've already talked about, necessary and indispensable defendants we'll talk about, Consumer Protection Act, and civil harassment. And those things I really do expect to see a lot in the answer. What I would expect from the statement of facts is that the statement of facts would go through each of those 5 things I just listed. The first one should be personal jurisdiction over the 2 defendants. And this should be, the court doesn't have personal jurisdiction over defendants. And then it should go into all the facts about why the court doesn't have personal jurisdiction. But it doesn't. It just says the background events leading to plaintiff's filing of this lawsuit, which are irrelevant to the 5 listed reasons as to why this should be dismissed. So I don't even know why this is in here. And at this point, we're 3 pages in. At this point, a judge is going to look at this and be like, why am I reading this? Why is this background relevant to these 5 things you've spelled out? And why are they spelled out this way? And why aren't you telling me what law the personal jurisdiction prayer is made for? Like, under what section are you saying I don't have personal jurisdiction over these defendants? And then tell me what facts support that. And then tell me what you would like me to do. But no, we get back into the fact that Ms. Westbrook falsely accuses a young rival of sexual misconduct to an audience of more than 47 million. The judge doesn't care about the tea at all. We do. We enjoy the tea, but we all saw By Sister and we have our opinions about it. The judge doesn't give a fuck about any of this because it's not relevant to any of the reasons it would be dismissed. So this entire section is not relevant. There was a footnote. You know, I love a footnote. Undersigned counsel is aware the cited evidence, I tell you, evidence. We're going to talk about the evidence in a minute because none of the evidence is evidence. Whew, we'll get there. Oh, The footnote is on the entire statement of facts. Okay. Undersigned counsel is aware that cited evidence includes profanity that would normally be inappropriate for judicial proceedings. However, the believes the evidence is important to convey the nature of the scandals that form the basis of this suit. Nothing about these scandals form the basis of the lawsuit. The basis of the defamation suit is the 40 videos that are listed in the defamation suit. And none of these YouTube videos that are listed in the appendix can be taken as evidence because they're not sworn statements. And they're not like the fact of the thing proves the thing. So the fact that they're actually citing to other people's YouTube videos as evidence causes me substantial concern. Like they're out of court hearsay. Like how are those evident? How are those evidence? Oh, I don't know. They're not. They're YouTube videos. The fact of their existence may be evidence. Like, hey, this video exists. But the videos about how other people feel about Bye Sister is not evidence. Videos of defendant saying shit about plaintiff is evidence. Videos of plaintiff saying shit about defendant can be evidence, but it would have to come up. There would be cross-examination. There would be depositions asking about the videos. The videos of the statements that KJ made are relevant because that's the defamatory statements. But what the fuck PewDiePie thinks about Bye Sister is completely irrelevant to whether there's jurisdiction in this case, and I don't even know why it's brought up. This hurt my head. It hurt my head. However, the believes it. So, statement of facts, section A1 is not relevant to any of the arguments here. It goes into Bye Sister. It goes into NBC News reporting about Bye Sister, the views on Bye Sister. It all Tati sucks because Bye Sister. Okay, cool, but not relevant. Ms. Westbrook tearfully blames two other rivals for her false accusations. Okay, breaking my silence is also not relevant to jurisdiction. I think they're trying to make it relevant to the fact that there's indispensable defendants, but it's a defamation case. So no, because Starr and Dawson weren't part of why KJ made statements. The only way you get these indispensable parties is if somebody else is also contributing to the harm. Like if you're in a lawsuit over the building of a house and you sue just the guy that did the windows and not the guy that did the framing, but the framing's part of the problem. The window guy can't fix it all because part of the harm was done by another party. But that's not the case here. Like the shit you said is the shit you said. If other people also said shit, it doesn't mean that what you said doesn't carry the weight of damages. It's an argument for the finder of fact saying, right, but my damages, like the stuff I said is less than the stuff that other people said, so my damages are low. So a jury's going to have to decide, were the statements made by KJ damaging, or was it, Trisha Paytas calling her stupid or something else? But that's a damages issue for the finder of fact. That has nothing to do with the complaint being faulty on its face. And that's where I'm struggling to connect some of these factual arguments with a motion to dismiss, because those are arguments for the finder of fact. Like I said in my video about, every video I've made about this case, that damages in cases like these are hard to prove, and a lot went down. But the damages argument is for the fucking jury, not for a motion to dismiss. Let's continue. This entire section about breaking my silence, I don't even think ties it back, because indispensable third parties are not relevant to a defamation claim or to this motion. This is more about the false accusations and breaking my silence. The Westbrook's business partner sues them for fraud and malicious misconduct. Okay. But are we trying to prove that the statements made in the defamation lawsuit have a defense of truth? Because this motion doesn't assert defenses. This motion says that there's no jurisdiction. So this is all irrelevant. However, it opens the door for it to be addressed by Tati's attorney. And I'm sure they're going to take a foot, kick that door open and be like, Oh, good. Now we get to talk about everything because they brought it up. It's not relevant, but they brought it up. I don't know why you would open that door in this. The Westbrooks sued defendants and no one else in Seattle for harm they previously claim was caused by Starr and Dawson at their Los Angeles-based conspiracy. Defendants were the first to report on the Swanson lawsuit. I think that's the third time it's brought up. It might be the fourth time. I think this goes to number 3, that these are indispensable third parties, but then it just goes back again into taking shots at Tati. But everybody watched those videos and knows, and then it goes into, but they did not bring their claim against Starr and Dawson. Instead, they only sued Ms. Paulson and her small, solely owned LLC, both Minnesota residents. Okay. And then they talk about the size of Miss Paulson's channel. I thought she had more subs than 135,000, but maybe things have changed. It states a position of the case that doesn't make sense to me, stating that the business injuries and the defamation injuries were because of defendants' reporting of the scandals. But that's not the basis for the suit. The basis for the defamation suit is the alleged improper extrapolation from those suits and then additional statements on top of it. Taking the business partner lawsuit, for example, and saying Clark Swanson said he used his banking relationships in the business partner lawsuit, and then extrapolating that to say, and they were broke and they had no bank accounts and they had no, money. Those extrapolations are what's being alleged here, not the fact that somebody said, look, somebody got sued. There's some tea here. She gets called greedy. The business partner called her greedy. Do you guys think that she's greedy? The business partner said she said this. Oh my God. And the business partner said that she was relying on James Charles, and maybe that's why she was so mad and Bye Sister. No, that's not what this suit's about. The suit's about the statements made of, he reverse mortgaged his mother's house a bunch of times and there was no money. That's not in the lawsuit from Hawaii. It's all those kinds of statements. So it's not the reporting of the thing that's the issue. It's the alleged defamatory and false statements that were extrapolated from the thing improperly. That's the basis of the lawsuit. Like, how are we missing the point at this point? I don't understand. Argument. The court may not exercise personal jurisdiction over plaintiffs. We got to an argument on page 7, but it's the wrong argument because the plaintiffs get to choose jurisdiction. Tati and James can sue where they want. They're just, look, I can't even get through this. Tati and James can sue where they want. They just have to show that enough of the shit they're alleging happened where they choose to sue to bring you there too. And federal jurisdiction is like, did enough happen here? We talked about this in the Johnny Depp lawsuit. Johnny Depp is suing Amber Heard in Virginia over an article that was published online by the Washington Post because the printing presses for the Washington Post are located in Virginia. So is the fact that you're making statements about someone who lives in Washington probably enough? Probably, but there's other shit too. Y'all, I don't understand why the plaintiff's jurisdiction is even coming up in this, because the plaintiffs are irrelevant because they get to pick jurisdiction. The only jurisdiction we care about is defendants. The complaint contains no allegations even suggesting this court may exercise personal jurisdiction with respect to plaintiff Halo's claims. Halo is a company that does business everywhere, and if their business was damaged because sales went down, then it would have been damaged where they do business, and they probably sell products everywhere. And if their managing members are in Washington, then, but again, plaintiff can choose where to sue. You just have to prove the defendant can come there. I don't know why we're still talking about plaintiffs. The allegations of the complaint, even taken as true, do not establish personal jurisdiction with regards to the Westbrooks claims. Plaintiffs' allegations do not satisfy the expressly aimed requirement. I think that they're saying, and I have to extrapolate because it's not just fucking said, I think that they're saying that the defendants don't have enough contacts or action in Washington, and that the defendants did not expressly aim their conduct as Washington. Look, it is hard, and I am trying not to be the grammar police because I am definitely not. You know that your girl's ADD and dyslexic, but stuff like that hurts my brain because I think that I've seen it wrong. And then I get frustrated. I'm like, am I reading it wrong? And then I second guess myself and then I get pissed. I'm like, no, it's what? But didn't expressly aim their conduct at Washington State. But if Tati and James lived in Washington, that's going to be enough. So I don't really know why we're talking about this. And then we kind of get into the defendant's contacts with the form, but why didn't that just get said? Like, why aren't we talking about the defendant's contacts with Washington? Let's talk about that. I want to talk about that because that's relevant. It does say that the defendant acknowledged Tati and James moved to the state of Washington. And I just want to bring up what's in the complaint on this because I had forgotten. I switched over to the defamation complaint. This is the plaintiff's filing defamation complaint. One of the defamatory statements and defamatory things alleged is that Tati and James listed their house for sale because they wanted to get rid of their assets if they lose the Swanson lawsuit so that people cannot get access to their money. That goes on to say that James liquidated all of his assets. Then it's said in the complaint that Tati and James moved to the state of Washington in 2018 and became permanent residents therein in 2019, a fact known by defendant Paulson, a fact known by defendants as Paulson has made mention of Tati's move to Washington in certain of her videos. Despite having such knowledge, defendants instead claim that Tati and James were selling a house that they no longer lived in for nefarious reasons. In this point, I said, oh, we hadn't been sure if Tati had moved or not. There was speculation online, but this is confirming Tati moved in 2018 and was a permanent resident in 2019. And the allegations in this complaint go through 2020. So even if they want to argue about whether there are contacts with the state, for a lot of these videos, Tati and James lived in the state of Washington. So back to the issue at hand. It's interesting to me that they say plaintiff's failure to identify specific statements by defendants in any specific video is notable, though in their response they may. They had access to these videos at the time they filed the complaint. Is had not have an acknowledgement that certain videos have been removed and or privated or made inaccessible? I don't know. This gets into satisfying the contacts, but that doesn't directly go to this point. So everything under these points is supposed to directly address that point, and this goes all over the place. This then gets into defendants' contacts with the state, even though it's not headed that way. Whether a judge will parse this as much as I'm trying to parse this, I don't even know. The something more requirement may be satisfied in defamation cases where, for example, 1, the defendant developed the defamatory story using sources from within the form. But haven't we seen videos of KJ talking about looking for things like Tati's birth certificate, which would be in Washington, her dad, who lives in Washington, her mom and her sister. I know she's mentioned her sisters in Washington. I don't know about her mom, but there are videos of KJ talking about the research that she's done, looking into Tati and her background, and then saying her given name, not her married name, and saying her name is this and that from Washington. She's just like basically a basic girl from Washington, and her name's not even Tati, it's this. We've seen those clips, but those all go to research done in Washington. The something more requirement from Washington is proven by KJ saying it's in Washington. And when I did this live last night, people were helpful enough to tweet clips of this. And Stacy's mom first, I very much appreciate you pulling this up. And I also very much appreciate your name because it reminds me of the Bowling for Soup song. I'm just going to pull this up because this goes to the point.
In 2003, we see Tati's first issue come up in the state of Washington.
First issue come up in the state of Washington. So then we're looking in Washington.
With a small sort of tax warrant where she doesn't pay her taxes and she has a judgment that's assigned to her in the state of Washington.
So now we're talking about the state of Washington, which proves the point that at least some research was done in the state of Washington. And that doesn't even get into the mom, the dad, the birth certificate, and all of it. You guys know the video I'm talking about. Like, is her dad in the mafia? Is he dead? Tati's made it really clear her dad lives in Washington. So the research would have been done accessing court records from Washington. We're moving on because I think that was clear. The story focused on plaintiff's activities within the form. Yes, there were stories that focused on the fact that they were moving and alleging that they moved for nefarious purposes of hiding assets from an ongoing lawsuit. So I think that argument fails on those two grounds alone. And I think that the response will point that out. We don't even need to get to the brunt of the harm because the other two fail. So we don't even need to get there. The allegations of the complaint are contradicted by the Westbrook's own public statements regarding their state of residence. There has to be proof, though, and I'm interested to see how this is handled in the response, because Tati saying things on social, okay, she said things on social, but the things aren't defamatory statements. So is, hey, I'm flying back to LA, proof that she still lives in LA and things like that? We'll see. It says that the allegations are certainly false, that they are not permanent residents. How are the allegations certainly false that they're not permanent residents? The only evidence attached with this, are a Zillow printout and tweets. It's not first person evidence. Okay. I imagine we will see some of that coming in the response, if it even needs to be responded to. We're still talking about whether they're domiciled in Washington, but I think we're talking about now, though it's not clear, if they're domiciled in Washington for the point that we're pointing at Washington for the harm. But again, it doesn't even come up because we see the defendant's contacts with the state of Washington based on her own statements on video. So the rest of that really doesn't even need to be addressed. And this lists out all the different social media posts that apparently prove in some way that Tati didn't live in the state of Washington. Even if those posts are all taken at face value and all of them are taken as true, which they're social media posts, but if all of those are taken as true, it still establishes that Tati moved to Washington before a good number of these videos are made. The complaint must be dismissed for lack of diversity jurisdiction. Diversity jurisdiction. But then it gets into, again, talking about the fact that the does are supposed to be Dawson and Starr, but in the complaint, it says that the does are people working with KJ. So it doesn't allege that the does are other people that caused harm in that way. It's saying that the does are people that would have worked with her that are unknown to plaintiffs. And then in her sworn declaration, she said she didn't work with a person in Washington. So then there would be diversity jurisdiction. So we're not even going to cover that anymore because it's not worth any of your time. Seek to join necessary parties. We've talked about this. It's a defamation suit. Joint and several liability isn't going to come up here with that. And the fact that other people also said shit goes to damages, but not to the cause of action on its face. The complaint fails to state a claim for intentional infliction of emotional distress. So they're saying that the complaint doesn't allege that it's severe enough, but the statements in the complaint say that it's severe. So again, this goes more to finder of fact for me. I'll be interested to see what the response is to this, because this is more like a 12B6 motion. Like, it's not pled on its face, but on its face, you have to take everything as true. And in the complaint, they allege that it's severe. So I don't know where this argument is going. The Westbrooks failed to plead extreme and outrageous conduct, but we have to take the complaint as true on its face, and then it leaves out a lot of the alleged statements. So I don't know how we get to a 12B6 motion on the fact that the statements aren't extreme and outrageous when all of the allegations are in that complaint and they don't address all of them here. So it's like it feels to me like they left out the ones that are the more extreme ones. And some of those are defamation per se, or can be defamation per se, like career criminal, but none of those are listed here. So you can't pick and choose on a 12B6. It has to be everything that's in this complaint is true, and everything you've said that's true is still not enough. And that's not what I'm seeing from that. They failed to allege severe emotional distress. And then it gets back into Starr and Dawson, which again goes to finder of fact. So we're moving on. You don't need to hear me beat that dead horse anymore. The complaint fails to state a claim for negligent infliction of emotional distress because it's not severe enough. We've talked about it. The complaint fails to state a claim under Washington's Consumer Privacy Act. I will be interested to see the response on this. Does the claim give rise to a public interest? Maybe, but we'll see. Could these claims injure the public? We'll see. I'm interested to see the response on that. So, of everything in here, I'm interested to see the response on this because when I read it in the complaint initially, I'm like, that's an interesting cause of action. So now we're actually going to get some explanation from Tati's side on why they are alleging this cause of action. And I'm interested to see that. So on all of them, I'm interested to see that. But even if the judge is like, yeah, Consumer Protection Act, we don't like it. All the defamation stuff isn't touched by this. Like causes of action can be dismissed without affecting the other causes of action. Fails to state a claim for civil harassment, alleging that a signed declaration needed to be pled and that there were some things that needed to be pled. I'll also be interested to see that because they don't make it clear what needs to be pled here because the rule isn't clear. I think this is a 12B6. I mean, fails to state a claim. This is a 12B6, but the judge just takes everything as true, saying it's more likely than not that this could go forward. So I don't think this is going to be dismissed on its face, but we'll see. I'm interested to see the response on that as well. That one gets some of the most attention, but again, even if those things get parsed out, all the defamation causes of action still stay. Conclusion, it should be dismissed. There is a request for judicial notice, but you can notice like the fact of the lawsuit, but you can't notice the contents of the lawsuit. So if they're trying to rely on statements in the Swanson suit as true, they're allegations. There's no sworn affidavit here. Yes, Swanson signed that lawsuit under penalty of perjury, but it's not sworn to this court. So it's a very interesting tack. The fact of the lawsuit can be taken notice of, but not the contents of it. And it goes on to say, please take judicial notice the fact of these videos and their contents. You can't take judicial notice of the contents of a PewDiePie YouTube video or Trisha Paytas saying that she thinks Tati Westbrook is stupid. If you want evidence that Trisha Paytas thinks that Tati Westbrook is stupid, ask Trisha to sign an affidavit. I would be fascinated to see Trisha's reaction to that. This is just the business lawsuit saying, please take judicial notice. Well, we can judicially notice the fact of its existence, but not the contents therein. I imagine Saltsy will say something to the same effect in their response, because what? And then there's a list of YouTube videos. They're all clickable, by the way. And we clicked through them in the live if you want to see them. There is something from What Do You Meme that defines Carmageddon. It's just, what? Why is What Do You Meme? Knowyourmeme.com, Carmageddon. What? You can't, please take judicial notice of the fact that Carmageddon. We're now on page 36. Trying to take judicial notice of stuff that's not evidence. Okay. That can't be evidence. Declaration of Michael P. Brown. So now we have two attorneys named Michael. Fantastic. On this channel, we call Saltsy, and we're going to call Mr. Brown because, or other Michael, depending on if we're feeling sassy. Below is a screenshot from Zillow.com. I actually can't believe I fucking saw this. I can't believe that I saw someone attach a Zillow screenshot as evidence in a federal court. But okay. And then there are tweets and Instagram posts that purport to show that Tati is not living in Washington. Yesterday after the video, a number of you said for this one, it's like back in LA, excited to get home to snuggle with Puka. A lot of you said that you thought that she meant she was traveling in LA, but was excited to get home back to Washington to be with her dog, and read it in that way. So these go on showing that Tati's, starting a new chapter. and saying that she would, like, she landed at SeaTac and somehow her going to SeaTac shows she wasn't living there, but people traveled. I mean, they used to. Maybe we've forgotten. I mean, 2020 has been a lot, but people used to travel back and forth. It doesn't mean they don't live there, but sure. December 11th, 2019, ready for a new chapter. Even if this is when Tati first told the public she moved, we know, if anything, from Breaking My Silence, which is referenced heavily in this video, that she said that she was unable to live in LA anymore after everything went down. And I still don't know why her jurisdiction doesn't really matter. And we've already seen that there's enough contacts, I think, with Washington from KJ that it's going to be irrelevant. And then there's a declaration from Catherine Paulson, but again, she's sued as Katie, so I don't understand. I believe I was and have been credited by other YouTube commentators as being the first to publicly report on Clark Swanson's October 20, 2020 lawsuit filed against the plaintiffs in this case. Okay, you were the first. I don't understand why that's in this declaration. I don't understand how it's even relevant to anything because it's not the basis of the law. Okay. It talks about living in Minnesota, but it said, I did not conduct any research in Washington state or rely on any Washington residents. Okay, if you didn't rely on any Washington residents, the Doe argument is done as sources in relation to the publications in which the lawsuit's based. But we saw research in Washington state based on her own statement in the video that I played. And this is signed under penalty of perjury. So we now have conflicting statements in a signed declaration, which is beyond problematic. Y'all, it's beyond problematic. I had remembered that there were videos of her saying, I looked into her dad, I looked into her sister. Those people all live in Washington, and looked into her birth certificate. We know she's from Washington, and we know that KJ knows she's from Washington because she said her name's from Washington. She's just like an average chick from Washington. So you were looking at Washington state records based on your own videos, but then say in this signed affidavit to a federal court that you didn't conduct any research in Washington. And at the end of the day, that part of this motion is going to be the biggest fucking problem, because that's a huge problem. I don't know how an attorney signed this or let her sign this declaration, knowing that those videos are out there and that it took Reddit all of 7 seconds. It took people 7 seconds to find those. That's hyperbole. It was not even an hour after my live last night that those clips came up on Twitter, because everybody remembered her talking about all of the research she did into Tati and James Westbrook and Tati's family from Washington. I imagine that the response will rely heavily on the fact that, well, the irrelevant stuff, and then on the fact that there is a signed declaration that stands now in apparent contradiction to her own statements. And that is going to be a big fucking deal. Federal courts don't play. The judge is going to be so annoyed with all of this anyway, because there is so much that is thrown in here, which is why I called it a fruit salad. It's like everything's in here. But just the fact that we now have a signed declaration that is contradicted by video is a big deal. And we will see how it plays out. I would love to know your thoughts down below. If you are interested, I love sharing the Law Nerd Shop with you guys. If you're interested, you're welcome to go to lawnerdshop.com. If you want to join a channel here, we do channel member only live streams, which are a lot of fun because some of the streams get very full and I get to answer your questions and chat with you. You're welcome to do that. The text crew is where I send out notifications of what I'm doing and chat with you guys, because the YouTube bell doesn't always work. But while you're here, if you want to do the YouTube things, go ahead and do the YouTube things. Bell, subscribe. I'm happy to have you here. Let me know what you think of this case. Like, this Tsunami 2020 is just, we're still rolling. We're still rolling. I'll talk to you in the next one.